Senate will come to order. The senators will please take their seats. The senators and all in attendance will please stand and be led in an invocation by the Honorable John A. Cosgrove, 14th Senatorial District. Following the invocation, everyone will please remain standing and be led in the Pledge of Allegiance to the flag of the United States of America by Nathan Hatfield, Assistant Clerk Links, Senate Clerk's Office.
Let's go to the Lord and ask for his wisdom. Lord, you know in this time in our state and our country, we need you more than ever. Let us ask for not material blessings, but for wisdom to do the best that we possibly can here. I want to share two of the best known scriptures, one from the Old Testament, one from the New. In the words of David, "The Lord is my shepherd, I shall not want. He maketh me lie down in green pastures. He leadeth me beside the still waters. He restoreth my soul. He leadeth me in the paths of righteousness for his name's sake. Yea, though I walk through the valley of the shadow of death, I will fear no evil, for thou art with me. Thy rod and thy staff, they comfort me. Thou preparest a table for me before me in the presence of mine enemies. Thou anointest my head with oil, and my cup runneth over. Surely goodness and mercy shall follow me all the days of my life, and I will dwell in the house of the Lord forever." And as Jesus taught us how to pray, I'd like to share with you, "Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our debts as we forgive our debtors. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory forever. Amen." God bless us all.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The clerk will call the roll. All those in attendance will please record their vote aye. Clerk will close the roll.
You have a quorum, Mr. President. Senate Journal for Wednesday, September 9th, 2020.
The senator from Washington, Senator Pillion, moves that the reading of the journal be waived. All in favor of waiving the reading of the journal will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 34, noes 6.
Ayes 34, noes 6. The reading of the journal is waived. The clerk will report any communication from the House of Delegates. Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I move we waive the reading of the communications from the House.
Thank you, Senator. The question is, shall the reading of the communication from the House of Delegates be waived? All in favor of waiving the reading will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 36, noes 4.
Ayes 36, noes 4. The reading of the communication from the House of Delegates is waived. The clerk will report any communication from the governor.
We do not have any, sir.
Thank you, Madam Clerk. Is there any business to come in the morning hour? Do any senators wish to be recognized?
John, you want to talk about meeting of courts?
Senator from Roanoke City, Senator Edwards.
Mr. President, there will be a meeting of the Judiciary Committee immediately following adjournment, say 15 minutes after adjournment. It'll be very short. We'll only take up one bill. But it's important that we have everybody here right after adjournment for the Judiciary Committee meeting. Thank you, Mr. President.
Thank the Senator. Senator from Hanover, Senator McDougal.
Thank you, Mr. President. Would the Senator from Roanoke yield for a question?
Will Senator yield?
I'll be happy to yield.
Senator yield, you have the floor.
Mr. President, I asked the gentleman what bill will be on the agenda this afternoon.
Senator has the floor.
If there's a House bill they sent over, is House Bill 5013 of Delegate Bourne.
Thank you, Mr. President.
Thank the Senator. Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I would move that we stand in recess now. Both caucuses want to meet for 30 minutes? Until 12:45 p.m. And I'll yield to Senator Locke.
Thank you, Senator. Senator from Hampton, Senator Locke.
Thank you, Mr. President. Upon recess, the Democratic caucus will meet.
In the tent. The tent.
What? In the tent. In the tent with the chandelier.
Thank the Senator. Senator from Roanoke City, Senator Edwards.
We're also going to hold a Judiciary Committee meeting. Apparently, we're not meeting next week, so we'll have a Zoom meeting of the full Judiciary Committee on Wednesday at 10 o'clock. Wednesday, what's that, the 18th or something? 16th, whatever it is, at 10 a.m. next week for the Judiciary Committee, full meeting.
Senator from Northern Fairfax, Senator Howe.
I would like to point out that we have a regularly scheduled meeting at 9:30 that morning of Senate Finance and Appropriations. So we will have a severe conflict. Yeah. Oh, I'm sorry. I'm sorry. Sorry.
Okay. Senator from James City County, Senator Norman.
Thank you. First of all, Mr. President, as I understood it, the Courts Committee, the Judiciary Committee will be meeting on Wednesday at 10 o'clock, and the Finance Committee and Appropriations will meet on Tuesday at 9:30. But while we are talking about meeting, upon recess, I would invite the members of the Senate Republican caucus to go camping with me and join me in the tent.
Thank the Senator. Do any other senators wish to be recognized? Seeing none, without objection, the Senate will stand in recess until 12:45. Senate will come to order. The senators will please take their seats. Clerk will call the calendar.
Senate calendar for Thursday, September the 10th, 2020. Regular calendar, House Bill on third reading. House Bill 5103, a bill relating to the General Appropriation Act, appropriation of funds for the Department of Elections.
Senator from Northern Fairfax, Senator Howe.
Thank you, Mr. President.
I'm sorry, we have two floor amendments.
But that's okay.
Two floor amendments. Senator.
Mr. President.
Senator from Bedford, Senator Newman.
Mr. President, I have a floor amendment, but I would yield to the senator from Fairfax if she has an additional motion.
Thank you, Senator. Senator from Northern Fairfax, Senator Howe.
Thank you. I would like to move to recommit House Bill 5103 to Senate Finance and Appropriations.
Thank the Senator. Question is, shall House Bill 5103 be recommitted to the Committee on Finance and Appropriations? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. House Bill 5103 is recommitted to the Committee on Finance and Appropriations.
Uncontested calendar, Senate bill on third reading. Senate Bill 5043, a bill relating to expungement of police and court records expungement fee fund created.
Senator from Bath, Senator Deeds.
Mr. President, I move that the bill pass. This bill is nearly identical to a bill we passed during the regular session of the General Assembly to expand expungements. The changes that we made in the Finance Committee and in the Judiciary Committee basically reduce the cost and the burden of expense on the people that are seeking expungement. I renew my motion that it pass.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 5043? Seeing none, the question is, shall Senate Bill 5043 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll. Ayes 38, noes 2. Senate Bill 5043 passes.
Regular calendar, Senate bills on third reading. Senate Bill 5025, a bill relating to Board and Commissioner of Health, emergency orders and regulations, duration.
Senator from Bedford, Senator Newman.
Mr. President, I move the bill passes. Speaking briefly to the bill.
Senators, the floor.
Mr. President, this is a bill that just ensures that the Board of Health joins in the commissioner anytime there's an emergency order, and they would work together on that. And to the question from the senator from Fairfax asking about whether or not this could be done in a Zoom meeting, the answer is yes. Thank you, Mr. President.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 5025? Seeing none, the question is, shall Senate Bill 5025 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk, close the roll.
Ayes 40, noes 0.
Ayes 40, noes 0. Senate Bill 5025 passes.
Senate Bill 507, a bill relating to criminal cases sentencing reform.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. Mr. President, I move that the bill pass and request permission to speak to the bill.
Thank you, Senator. You have the floor.
Thank you, Mr. President. Ladies and gentlemen of the body, you remember this bill that passed almost in identical form in the last General Assembly session with bipartisan support and fairly robust debate. It is generically being referred to as the Sentencing Reform Bill. And the main component of this bill is that a defendant can avail himself of his constitutional right, both federal and state, to a jury trial, but then have the judge sentence him. As many folks know, Virginia is an outlier on this. There are 44 states and the federal government that allows jury trial but judge sentencing. Virginia is not one of those. There are the most, I think, important part of this bill is the following. There's probably not, I know, not probably, I know there's not a person in this room that believes that a defendant's constitutional rights should ever be chilled. But that's what's happened in Virginia with so many defendants. They are presented with an option. Take this plea or take it or leave it. And if they leave it, they get a jury trial and a jury sentencing. So it chills the right to a jury trial. And I hope that the body will pass SB 5007.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5007? Seeing none, the question is, shall Senate Bill 5007 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. Senate Bill 5007 passes.
Senate Bill 5018, a bill relating to conditional release of geriatric or terminally ill prisoners. And we have a floor amendment.
Senator from Eastern Fairfax, Senator Servell.
Thank you, Mr. President. Ladies and gentlemen, there's a couple amendments that need to happen to this bill, so I just want to rewind it really quick and take it by for the day, but I want to do the rewind today. So, Mr. President, having voted on the prevailing side by which we passed and engrossed Senate Bill 5018, I move we reconsider that vote.
Thank the senator. The question is, shall the vote by which the bill was ordered engrossed in advance to its third reading be... Okay, no problem. Good. Question is, shall the vote by which the bill was engrossed in advance to its third reading be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The motion is agreed to. Senator from Eastern Fairfax, Senator Servell.
Thank you, Mr. President. As I said, myself, the senator from Loudoun, and I think the senator from Lynchburg are working on some amendments to this, and so I'd ask that this bill go by for the day.
Thank the senator. Without objection, Senate Bill 5018 will go by for the day.
Senate Bill 5024, a bill relating to law enforcement misconduct.
Senator from Portsmouth, Senator Lucas.
Thank you, Mr. President. Mr. President, I move that the bill pass and speaking just momentarily to the bill.
Thank you, Senator. You have the floor.
Yes, sir, Mr. President. What Senate Bill 5024 does is it authorizes the Attorney General to investigate any department that has any issues with behaviors of police officers. And what the amendment added to it was that if by chance they receive a consent decree, if they don't comply, then their 599 funds will be affected. That's essentially what it does. Again, I move passage, Mr. President.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5024? Seeing none, the question is, shall Senate Bill 5024 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. Senate Bill 5024 passes.
Senate Bill 5030, a bill relating to policing reform.
Senator from Eastern Fairfax, Senator Servell.
Thank you, Mr. President. Could that bill just go by temporarily?
Without objection, Senate Bill 5030 will go by temporarily.
Regular calendar Senate bills on second reading. Senate Bill 5017, a bill relating to local correctional facility definition. Reported from the Committee on Finance and Appropriations. and reported from the Committee on Rehabilitation and Social Services with amendments, and from the Committee on Finance and Appropriations, and there is a floor substitute.
The senator from Northwestern Fairfax, Senator Boysko.
Thank you, Mr. President. I move that the committee amendments be agreed to.
Mr. Chairman. Point.
Thank you, Mr. President.
Point.
With the recommendation that we reject the floor amendment,
Substitute it, correct.
the floor substitute, I move that we accept the substitute.
Yeah, I've got it.
Let's, I think, to start, we're dealing with the committee amendments.
Right. I would prefer that we move the committee amendments, which is what I said at the beginning.
Right, okay.
Mr. President.
Senator from Lynchburg, Senator Peake.
Yes, parliamentary inquiry, Mr. President. If we follow through on that motion from the senator, does that mean that we will not be able to take up the floor substitute?
That's correct. If the committee amendments are adopted, then the floor substitute would then be out of order, and we could not take it up.
Then speaking to the motion.
Senator, it's the floor.
I would encourage everyone to vote against this motion so that we can get to Senator Marsden's substitute bills. And so I will save my comments about the importance of the substitute bills once we defeat this motion. But no one in the Senate knows more about prisons and facilities than Senator Marsden, and his substitute is critical for Farmville area. And so I would ask that we defeat the motion now pending.
Mr. President.
Thanks, Senator. Senator from Northwestern Fairfax, Senator Boysko.
Speaking to the bill and the amendments, sir.
Senator, it's the floor.
Thank you so much. This bill, as amended in committee, would change the definition of local correctional facility to mean any jail, including a jail that is a facility that's owned, maintained, or operated by any political subdivision or combination of political subdivisions in the Commonwealth used for detention or incarceration of people pursuant to a contract or a third-party contract with the federal government or any agency or contractor thereof. This bill would allow the state board of local and regional jails to set minimum sanitation standards and to allow for unannounced inspections. It would allow the board to prohibit confinement and require the transfer of prisoners in substandard facilities. It would allow the board to review the death of an inmate, provide circuit courts with the authority to enforce the board's orders, and allow access for the interior of the facilities by members of local governing bodies, Department of Corrections staff, and state and local health departments. As you are aware, there was a rampant COVID-19 infection at the Farmville facility where almost every single person came down with it, including many of the members of the staff. And there was a refusal by the facility to allow the Virginia Department of Health to come in and help with the testing. This would change that. During that time, many people, including federal legislators, our senators, Governor Northam asked the federal government to allow the CDC to step in, and it took a lawsuit to bring the federal court to bring the oversight. This has been vetted by the Attorney General's office. I have also amended the bill to address some concerns by the Department of Public Safety, and I move that the committee amendments pass.
Thanks, Senator. For what purpose, Senator from Western Fairfax, Senator Marsden rise?
Mr. President, I have a parliamentary inquiry.
Senator from Bedford, Senator Newman.
Just a parliamentary inquiry. Mr. President, my parliamentary inquiry is that if those individuals that want to get to the bipartisan substitute, would it be proper to have a substitute motion to pass the floor amendment?
Yeah, a lot of people.
Senator will temporarily go at ease. Senate will come to order. Senators will please take their seats. Senator from Bedford, Senator Newman.
Mr. President, I withdraw my parliamentary inquiry, but I have a separate motion, Mr. President.
There's the floor.
I make a substitute motion that the committee amendment go by temporarily so that we can get to the floor substitute, which I think there may be some broad support for. So that's my motion, sir.
Thank the Senator. The substitute motion is to have the committee amendments go by temporarily to take up the floor substitute. All in favor of the substitute motion will say aye. Aye. Those opposed, no. The ayes have it.
Well done.
The committee amendments will go by temporarily, and we will now take up the floor substitute. The senator from Western Fairfax, Senator Marsden.
Thank you, Mr. President. You have two amendments on your desk. One is entitled number 2. The other one is not does not have a number on it. I would like to withdraw the one without the number 1 on it.
Without objection, floor substitute number 1 is withdrawn.
Okay. And floor amendment number 2 is what we're taking up. I don't have any problem, Mr. President, with the intent. Waive the reading of the floor amendment.
Thank the Senator. The question is, shall the reading of the floor amendment be waived? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The reading of the floor amendment is waived. Senator from Western Fairfax, Senator Marsden.
Thank you, Mr. President. I have no problem with the intention of the Senator from Loudoun's bill. As a member of the Finance Committee, I'm concerned about a number of things, mostly, obviously, cost. I am concerned that we are requiring, I believe, the Department of Corrections through the State Board of Local and Regional Jails to hire somebody to conduct these inspections. I'm also concerned, Mr. President, with the fact that if this bill goes through as it was introduced with the Senator's amendment, which we have yet to hear, is that ICE, who controls the facility in Farmville, run by a private organization under contract to ICE in the city of Farmville, that ICE is not going to let this go in, and we're going off to the federal courts. And the problem that occurred at the ICA facility, which holds immigrants, most of whom are minor criminal charges, the problem began when ICE did something irresponsible. Mr. President, they put inmates in there without testing them, coming from another state, and it created a COVID outbreak and led to lawsuits and all kinds of difficulties. Now, the Senator from Loudoun, in a previous explanation, talked about the fact that in California there was a ruling that these facilities could be under certain state regulatory authority. But what it did not change is the fact that ICE can put anybody they want to in this facility. That ruling in California did not deal with that, did not change that. Very much as though a company of soldiers can't be transferred from Fort Gordon to Fort Lee with, that they'd need the permission of the state to do that. They can put anybody they want in there. The the federal regulations that operate these facilities are far superior to those of Virginia. And if I could just go through very quickly, and I don't mean to take up too much of the body's time, but what the state will do is an annual inspection where they will come in and view these facilities under state rules. The federal government has rules and regulations for the operation of medical procedures and all procedures that are far superior to those of the Commonwealth of Virginia. We just inspect them one time a year, but it would allow them to, if ICE permitted it, allow them to go in at other times if there were problems. But not only is there an annual inspection by ICE, there's one by the American Correctional Association, the National Commission of Correctional Health Care, the Prison Reform Elimination Audit that would take place, plus unannounced visits from ICE personnel from Washington, D.C. and the Richmond region. The problem is not that this facility doesn't have good medical procedures. The problem was created by who got put into this facility. And what this substitute does is gives the chief of the State Board of Local and Regional Jails permission a requirement to ask ICE to go into the facility to conduct an audit on the federal standards, which are far superior to the state standards. In other words, is the federal government doing what they're supposed to do, not under our less than ideal state standards, but on the superior federal standards? They have full-time doctors. They have dental clinics. They have x-ray machines. They have all kinds of things that our local jails don't have. And the senator from Loudoun's bill does not change the fact that they can put anybody in that facility that they so choose. And what I'm worried about here is, despite all the health care and the circumstances that exist in that facility, is that ICE will say no, that we can't come in, and then we're off to a disagreement with the Ninth Circuit, because this will end up in the Fourth Circuit. We're picking a fight with somebody we shouldn't be picking a fight with. They have deep pockets, deep resources. The city of Farmville is part of this contract. They're going to have to hire an attorney to represent them. We're going to have costs from DOC, and these litigation costs for the federal government are to take this through the court system is going to be severe. So what we've got is a voluntary agreement here that I believe ICE will follow through on. It's been indicated to me that they are likely to do that. I have toured the facility personally. I have toured it. I spent several hours there. It wasn't a detailed audit, but it's a well-run facility. It has all the bells and whistles that most of our local jails don't have. They can take care of COVID prisoners as well as anybody. The way the federal government is doing it now, the way ICE is doing it now, their procedure is everybody spends at least 12 days in the Caroline County facility, before they are transferred to this facility. The Caroline facility has individual cells where they can isolate. The facility in Farmville does not. It is an open bunk bed kind of arrangement for several hundred prisoners. Right now, they're not accepting new inmates because of this new procedure that they have. But I am trying to save the state money. The time and trouble of a federal lawsuit, and the concern that Farmville has over the costs, the litigation costs that they will incur. And Mr. President, I'll close with the fact that you can't predict what the federal government is going to do. This Farmville facility represents 250 jobs. I assume the one in Caroline County is similar to that. If we present ourselves as difficult to deal with in this circumstance, then I'm worried that they may transfer their facilities elsewhere, costing us jobs. I can't say that they're going to do that, but it's an unpredictable situation. This is a fight we don't need to have. I think they'll let us come in a pandemic. They'll let us come in and investigate the place based on the standards that they have in place, and that will be a better arrangement for those residents of that facility, for the Commonwealth of Virginia, and for our state budget. And so that is what the substitute does, and I'd be glad to answer any questions.
Thank the Senator. For what purpose is Senator from Arlington, Senator Favola, rise?
Thank you, Mr. President. I'm speaking to the substitute.
Senator's the floor.
Thank you, Mr. President. Rehab and Social Services did hear this bill in committee, and I just want to point out a few things. I have the greatest respect for my colleague, Senator Marsden, but I have to say, listening to his presentation, it seems to be a lot of concern about something that is really not likely to happen. The bill merely allows the state to go in and monitor this Farmville facility as though we were monitoring regional or other local facilities. And I think you might ask why. Why are we even bothering? Well, I will tell you, on the ICE website itself and on documents that ICE has published, there hasn't been a federal inspection of Farmville since February 28, 2019. Well, as you know, the governor implemented an executive order in March 12th. So for this whole time, we haven't, according to ICE, its own report, they haven't gone in to monitor. I would submit, and I believe members of the committee would submit, that we do in fact have a vested public interest in understanding what kind of health conditions are really going on in Farmville. We have Virginians who are working at the Farmville Center. We have suppliers who are going in and out, providing catering services or housekeeping services or whatever. All of those folks are in our communities. All of those folks could be conduits for spreading COVID-19. Federal government's under no obligation to pay for the health capacity the state would have to create if, in fact, we allowed extensive or egregious health situations to take place. And I do want to say that we, the state, the Department of Health has gone in with the Department of Corrections and monitored other facilities. But you should know that the whole intent is to be collaborative. The state has never taken, according to the Department of Health, we have never taken a regional or local facility to court. Now, some might say we're not aggressive enough in applying standards, but I want to remind you, when the state goes in, We are monitoring against CDC health regulations. That's a federal body. That's the body that does infectious diseases and control. That's the federal body that provides the interpretation of research into practice when it comes to good public health. We've never taken a facility to court. We want to work with our facilities. We want them to get the best outcomes possible. And that's all this bill is intended to do. It's all. We just want an opportunity to go in and work with the facility. And we believe that, in fact, there's enough of a public interest that you would want us to go in and work with the facility. Lastly, ICE expects their federal detention facilities and the managers of their federal detention facilities to publish plans on how to address public health outbreaks and, quote, these standards or these plans must include collaboration with local health departments. So it is the expectation of ICE that the contractors they're hiring to run these centers will in fact work with the states that they're located in. I don't see the boogeyman in this bill. I really do not. But I'm interested in hearing more from my colleagues, and I hope we can look at this with an open mind. And I do thank my senator, my colleague, for bringing this bill forward. Thank you, Mr. President.
Mr. President.
And Senator from King George, Senator Stewart.
Would the gentlelady yield for a question?
Will Senator yield?
Yes, I will yield.
Senator Yields, you have the floor.
Thank you, Mr. President. I would ask the gentlelady, my understanding, and maybe I need to phrase this a different way, my understanding, having heard this on the floor because I'm not in the committee, is that under the gentlelady from, where's Senator Boyce go from?
Loudon.
Her bill, it's a mandate that the state go in and monitor a federal facility. And the gentleman from Fairfax is proposing a bill where it would be a collaborative effort with the federal government seeking to come in and monitor it on the federal standards. Is that correct?
Senator's the floor.
I would respond by saying I believe the bill that the senator from Loudon introduced, the senior senator from Loudon, accomplishes the same thing. I guess I'm having trouble understanding why we would need the substitute. I don't interpret the bill before us, not the underlying bill. I don't interpret that to create the lawsuits or mandates that I guess the other senators might seem to think would exist.
Further question?
Yes, with gentlelady yield for another
Senator
question.
Yield.
Yes, I yield.
Senator Yield, you have the floor.
I would ask the gentlelady, Mr. President, would not, if I read this bill correctly, the senator from Loudon is proposing a mandate that we monitor a federal facility, and would not the doctrine of federal preemption preclude that from happening? As I understand the law, a state can't mandate anything to the federal government because of the doctrine of federal preemption. And so is not that exactly what the senator from Fairfax is talking about, where this whole thing's going to end up in federal litigation?
Senator's the floor.
Thank you. Again, my response is I believe that the interpretation from the Senator Stewart is that this is going to be a hard and fast, aggressive monitoring with a penalty, and the state has never applied a penalty. The state has never taken a facility to court. So I don't see why this bill doesn't bring us down the collaborative path just by the way the state has always interpreted or exercised its monitoring ability. That's my response. Thank you, Mr. President.
Thank the senator. For what purpose does the senator from Lynchburg, Senator Peake, rise?
Yes, sir. Thank you, Mr. President. I rise to speak in favor of the floor substitute.
Senator has the floor.
And I understand the senator from Loudon's concerns, and I think her bill is well-intentioned to addressing those concerns. I think we all want to make sure that any ICE detainees that are held in the Commonwealth are treated humanely, fairly, and kept safe as possible. And I can assure the members of this body I toured this facility a year or two ago, and before any of these problems broke out, and they took tremendous pride in the steps that they took to ensure the well-being of the detainees that they were keeping. And they continue to maintain those standards. What happened in this incident is that detainees were sent from out of state. I know a large batch from Arizona and another batch from out west, where ICE told the facility that they had been tested and they were all COVID-free, when in reality, that turned out not to be the case. A number of them were positive, and then it spread in the facility because this facility attempts to be as minimally restrictive as possible. They do not have individual cells. They're allowed to mingle. They try to keep it as congenial and free as possible for a detention facility. And they want to continue to do that, and it's my belief that currently they have not been sending any more detainees there, that the facility is now COVID-free. And now to address the senator from Arlington's questions, the whole issue is, as Senator from King George mentioned, is federal preemption. So it's not that the state is going to sue the facility. That's not the concern at all. The concern is, and it's pretty much a given, that if we pass the original bill, and what it does, the original bill mandates that state corrections can go in there at any time that they want and inspect the facility. And ICE does not allow this. They're a federal prison. They have their standards, which are higher than state standards, and they are not going to allow a state to go into their facilities at any time that the state wants. Any of these inspections must be coordinated and worked out with the federal government. So if the bill passes as it's written, there will be a lawsuit. And the contract is with ICE to the town of Farmville. The town of Farmville is not a wealthy community. They have Longwood, they have the Green Front, and then this ICE facility is probably one of the next 3 or 4 top employers with over 250 employees at the facility. It's a private-run facility. The private-run facility contracts with Farmville. So when ICE files suit, it'll be against the Commonwealth, it'll be against the town of Farmville, and it will be against the private facility. A bunch of unnecessary legal fees, from the state at a time when we're running a deficit, a bunch of unnecessary attorney's fees for the town of Farmville, which can hardly afford it. And so that is the real issue. And the way that the senator from Western Fairfax's substitute allows it can be worked out so that there will be inspections by the state. And I have received commitments, I believe the senator from Western Fairfax has as well, that the facility will cooperate with the Department of Corrections to allow inspections. As I said, they have done everything they can to eliminate the COVID virus in the facility at this time. But if we do not pass this substitute, there will be litigation and it will be costly. So I encourage the members of this body to vote in favor of the substitute.
Thank the senator. For what purpose the senator from Northern Chesapeake? Senator Sproul rise.
Thank you, Mr. President. Speaker to the bill.
Senator has the floor.
Thank you. Mr. President and members, look at this thing very carefully. This bill got out of the committee 8-6. The substitute, I went to the Patriot and I asked the Patriot, was the substitute from Senator Morrison, did he really sit down with you and go into it in detail about the substitute? No, very briefly. And here we're sitting here now taking a substitute that should have been discussed by members of this side of the aisle. We went outside in the tent, there was no discussion. The members of the committee had no discussion. This is the first time that we are saying the substitute. And I'm looking at it, why is it that right now those who are speaking in favor of the substitute are my friends on the other side of the aisle? Why are all of the members on that side of the aisle speaking for the substitute and members on this side of the aisle? We are cutting our own members' throat. And it's her bill. You would have at least a thought that someone on this side of the aisle would at least sit down with her bill and say a substitute is better, and why? And it's her bill. And now we're getting all the support from the other side of the aisle about a substitute, and we are not doing nothing. I am voting against this substitute because it's not right for the members on this side of the aisle, the Democrats. It's not right for y'all to allow this substitute to pass because we are not giving our sister girl a fair shake. Thank you.
For what purpose, the senator from Fairfax City, Senator Peterson.
Mr. President, rise for motion.
Senator's the floor.
Mr. President, I move this bill go by for the day.
Any objection? Without objection, Senate Bill 5017 will go by for the day.
Senate Bill 5035, a bill relating to law enforcement civilian review boards. Reported from the Committee on the Judiciary with a substitute and from the Committee on Finance and Appropriations with a substitute.
The junior senator from Chesterfield, Senator Hashmi.
Thank you, Mr. President. With a request that we reject the substitute from the Judiciary Committee, I move the substitute.
Thank the senator. With the recommendation that it be rejected, the question is, shall the committee substitute from the Committee on the Judiciary be adopted? All in favor of the motion will say aye. Those opposed, no. The noes have it. The committee substitute is rejected. The junior senator from Chesterfield, Senator Hashmi.
Mr. President, with a request that we adopt the substitute from the Finance Committee, I move the substitute.
Thank the senator. The question is, shall the committee substitute from the Committee on Finance and Appropriations be adopted? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The committee substitute is adopted. The junior senator from Chesterfield, Senator Hashmi.
Thank you, Mr. President. I move that we engross and advance SB 5035 to its third constitutional reading. Speaking briefly to the bill.
You don't have to, Senator, on the engrossment.
Okay. Thank you. I move that we engross and advance it to the third reading.
Thank the senator. Question is, shall Senate Bill 5035 be engrossed and advanced to its third constitutional reading? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The bill is engrossed and advanced to its third constitutional reading.
Uncontested calendar, Senate bill on first reading.
Senior senator from Fairfax, Senator Saslaw.
Mr. President, I move that all Senate bills on first reading on the uncontested calendar, on the uncontested and regular calendar, pages 7 through 9, that's Senate Bill 5014 through Senate Bill 5118, that the rules be suspended and the first constitutional reading of the titles be dispensed with.
Thank the senator. The question is, shall the rules be suspended and the first reading of the titles of Senate bills on the uncontested and regular calendars, pages 7 through 9, Senate Bill 5014 through Senate Bill 5118, be dispensed with? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote?
If they can vote to suspend that.
Clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The reading of the titles is dispensed with. Senior senator from Fairfax, Senator Saslaw.
Mr. President, I move that those bills now go by for the day.
Thank the senator. The question is, shall the Senate bills on the uncontested and regular calendars now on the second reading go by for the day? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The bills will go by for the day.
Memorial resolutions.
Senior senator from Fairfax, Senator Saslaw.
Mr. President, I move that the memorial resolutions on page 9, that's SR 535 through 537, be considered in a block in the usual manner, waiving the reading of the resolutions thereof with the understanding any senator desiring to remove resolution from the block will do so after the clerk has read the title of the resolution.
Thank the senator. The question is, shall the memorial resolutions on page 9, Senate Resolution 535 through Senate Resolution 537, be considered in the block in the usual manner, waiving the reading of the resolutions thereof, with the understanding that any senator desiring a resolution be removed from the block will do so after the clerk has read the title of the resolution. All in favor of the motion will say aye. Those opposed, no. The ayes have it. The motion is agreed to. The resolutions are before us in the block. The clerk will read the titles of the memorial resolutions.
Senate Resolution 535, celebrating the life of Howard H. Faust, Jr. Senate Resolution 536, celebrating the life of Leonard Jackson Height. Senate Resolution 537, celebrating the life of the Honorable Bonnie Lineweaver Paul.
Mr. President,
Senator from Rockingham, Senator Obenshain.
could Senate Resolution 537 come out of the block?
Without objection, Senate Resolution 537 will be removed from the block. The resolutions will be agreed to in the usual manner. All those in favor of agreeing to the memorial resolutions will please rise. Resolutions are agreed to. Senator from Rockingham, Senator Obenshain.
Mr. President, I move that Senate Resolution 537 be agreed to, and speaking briefly to the resolution.
Senator's the floor.
Mr. President, members of the Senate, I pulled this out because, as is our tradition, this relates to a former member of the General Assembly. Bonnie Paul was a member of the House of Delegates in 1975. I'm not sure that anybody other than Senator Saslaw actually served during the time that Bonnie was a member of the House of Delegates. But Bonnie Paul was just a classic Mountain Valley Republican. She was somebody who was fiercely independent. She did what she believed in, no matter whose feet she stepped on. And she stepped on my toes a time or two over the years, and I'm sure I stepped on her toes as well. But Bonnie served 2 terms in the House of Delegates, and after serving in the House of Delegates, she kind of did the reverse career development, went to law school at Washington Lee University School of Law, had a long and distinguished career practicing law in the Shenandoah Valley. One of her daughters, Penny Paul Imeson, was my across-the-street neighbor, and about 10 years ago, Bonnie moved in to a home down the street from me, and we loved getting to know Bonnie better during that time. She was a treasurer in the Shenandoah Valley, was active in many civic affairs, very active in the Historical Society, and she will be greatly missed by the citizens of the Shenandoah Valley and by her family. And with that, I renew my motion that this resolution pass.
Thank the Senator. Senior Senator from Fairfax, Senator Saslaw.
Mr. President, this is pretty much of a surprise to me. I didn't know that she had been ill. Bonnie came into the House the same year I did, in 1976. And, she left the same year I did, not because I left, but and occasionally we stayed in contact over the years. She was one of the nicest, kindest people that I've ever met. One time when, probably about 15 years ago, we had the General Assembly, or maybe it was one of the committees, had a meeting up in the Harrisonburg area, and I met with her for lunch, and she hadn't changed a bit. But let me assure the other 39 of you in here, you would have liked her if you'd have known her. She was just a really sweet person.
Thank the Senator. Do any other senators wish to be heard regarding Senate Resolution 537? Seeing none, the resolution will be agreed to in the usual manner. All those in favor of agreeing to the memorial resolution will please rise. The resolution is agreed to.
Commending resolution. Senate Resolution 538, commending Geraldine Bailey Williams Johnson.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. Mr. President, I'd move that SR 538 be agreed to, and speaking very briefly to it.
Senator, it's the floor.
Mr. President, members of the body, Geraldine Bailey Williams Johnson is a beloved member of our Richmond community, and she was fortunate enough to celebrate her 100th birthday on August 31st. I'd ask that the body agree to SR 538.
Thank the senator. Question is, shall Senate Resolution 538 be agreed to? All in favor of the motion will say aye. Those opposed, no. The ayes have it. Senate Resolution 538 is agreed to.
Returning to page 5, Senate Bill 5030.
Senator from Hampton, Senator Locke.
Thank you, Mr. President. My apologies for not being here so that this bill could get its initial hour discussion. I move that Senate Bill 5030 pass, and speaking to that.
Senator has the floor.
Thank you, Mr. President. We all know that this bill addresses policing reform, and Senate Bill 5030 is quite comprehensive. It addresses many aspects of policing reform that citizens and advocates in the community have communicated to us that are important to put Virginia on the path to a fair and equitable system. We have heard in discussions over these last few weeks from some who oppose this legislation that we should not allow what happened over 1,200 miles from here to dictate policy in Virginia. But we have blinders on if we think that Virginia is immune to misconduct and the things that have happened in other parts of this country as it relates to that misconduct. This legislation is transparent. We have talked to many stakeholders as it relates to what this bill covers. We have addressed many concerns and issues. It's gone through many iterations in addressing those concerns and issues. Not everyone is happy with this legislation on either side. So that means that obviously we've reached a happy medium in terms of a compromise, if not everybody's happy with it. So I'm not going to go through everything, but we believe that this bill brings equity to Virginia policing. It covers it prohibits no-knock warrants. It bans sex with individuals arrested by law enforcement officers. It prohibits hiring of officers fired or resigned during use of force investigations. It creates a decertification process for law enforcement officers. It bans chokeholds and strangleholds. It requires attempts at de-escalation prior to use of force. It requires warnings before shots are fired. It requires law enforcement to exhaust all other means prior to shooting. It creates duty to intervene by fellow law enforcement officers. It prohibits shootings at moving motor vehicles and other issues that have been outlined in this legislation that we have discussed previously in committees. With that, Mr. Chairman, certainly we will entertain any questions that others may have with regard to this legislation.
Thank the senator. For what purpose, the senator from Rockingham, Senator Obenshain, rise?
Mr. President, first I would ask if the senator from Hampton would yield for a question.
Will Senator yield?
Certainly.
Senator yield. You have the floor.
Mr. President, I would ask the gentlelady whether she would direct her attention to the provisions dealing with the composition of the Criminal Justice Services Board and the Committee on Training on lines 418 and then 484. It's virtually identical language, and it discusses changing the composition of those two boards and commissions. It says that it should now include an attorney representing civil liberty groups. What is that?
Senator has the floor.
Mr. President, I would ask if the senator from Arlington would address that. she was concerned with that issue.
Thank you, Senator. Senator from Arlington, Senator Favola.
Yes, thank you, Mr. President. The expectation was that it would, apologize, the expectation was it would be somebody representing, say, the ACLU or a similar group. The intent of the changes made on these lines was to bring a broader perspective to the conversation on training and what a training curriculum should look like.
Mr. President, I would
Senator
ask
from Rockingham, Senator Obenshain.
Perhaps the gentlelady from Arlington would yield for a further question.
Will Senator yield?
Yes, I will yield.
Senator yield. You have the floor.
And I appreciate that, and I kind of gleaned that that might be the intent of whoever on the, I guess, the committee of drafts people who put this together might have intended, but I wonder if you look at other civil liberties and constitutional rights, whether perhaps an attorney who represents, for example, Virginia Citizens Defense League or the NRA would qualify under that language.
Senator has the floor.
It's an interesting question. It's always nice to work with lawyers. I would respond to my colleague from Rockingham that the intent was to look at groups defending sort of civil liberties. We don't elaborate. I expect the appointing body would try to, in totality, achieve what the intent is of this legislation. I mean, clearly we add a mental health provider, we add somebody from the Indigent Defense Commission, I believe that's in there. So I cannot definitively say yes or no to your question because I don't define the civil liberties is not defined in this statute.
Mr. President, further questions?
Further questions, Senator Yield? Senator from Arlington,
yes,
Senator Yield?
yes,
Senator
I
Yield, you have the floor.
Yes.
So if an attorney who represents an organization committed to defending Second Amendment rights was appointed to that slot on these two boards, it wouldn't be contrary to your intent as the draftsperson of that provision, as I understand your desire to make it equal and not content neutral.
Senator has the floor.
Would I be in error?
Yes, you'd be in error. Mr. President, I would respond to the senator from Rockingham. It was my intent that somebody be appointed that is traditionally advocating for the range of constitutional rights that individuals would come in use when they have an interaction with the police. As we all know, due process and 14th Amendment, there are a number of amendments that could come into play when an individual interacts with a police officer. So I was anticipating it would be somebody from perhaps the Civil Liberties Union, not the NRA. So there's, I guess, are you suggesting this is flawed?
Oh, I think it's just fine. Thank you very much. Mr. President.
Senator from Rockingham, Senator Obenshain.
If I may speak to the bill.
Senator has the floor.
Briefly. You know, first of all, I do want to commend the group of draftspeople for their efforts. I think that as this bill has evolved, it has changed a great deal. And there are some very good things in this bill that I think many of us would not hesitate to be very supportive of, especially if they were in self-contained bills. There are parts of this that I would readily embrace and would readily support. So before I launch into a couple of concerns, I just want to say thank you to particularly Senator from Eastern Fairfax, Senator from Hampton, and I guess Senator from Arlington, although I'm not sure that we agree on that last point. But thank you for your efforts and your open-mindedness and your concern about trying to address some of the concerns that have been expressed by some in the law enforcement community as well, and address public safety issues. But I want to raise just a couple of points. First of all, the point that I just addressed, I would respectfully submit that I think we've got a real problem if we're going to look at civil liberties and pick and choose which of the Bill of Rights are representative of civil liberties in this Commonwealth and in this country. Some of these self-proclaimed civil libertarians seem to believe that there are greater civil liberties, some civil liberties are greater than others, and I thought there for a minute that, that this provision might actually be more content neutral and be intended to protect all 10 of the components of the Bill of Rights as opposed to selected provisions of the Bill of Rights, and hearing that it is intended to encompass organizations that protect certain of the rights embodied by the Bill of Rights does give me profound concern. I would also point members to a couple of other provisions. You know, I think that it is really important for us to make sure that we do get bad cops off the street. I think we all, and we had a robust discussion about that yesterday with the proffered amendment to this bill. But, and I understand that amendment was rejected, but I have a profound concern that the opposite perspective, the perspective of baking into this bill union protections for bad cops is already baked into this bill. And if you look at the decertification provisions on lines 683 to 685, it does exactly that. If the disciplinary process contained in this or referenced in this bill is overturned or the outcome of it is overturned as a result of an appeal of that process, presumably through the collective bargaining process, you've got police officers who may have been fired who get their job back because union has wound up getting them suspended for a year as opposed to being fired, and that police officer is not going to be decertified under this particular bill. I also have concerns about the search warrant provisions in here, and perhaps the senator from King George has some of the similar concerns. I think we've discussed these previously, but my concerns may be slightly different from his. The provisions of this, I would submit, are going to create significant avenues for protracted and hotly contested litigation. As you will see, the provisions dealing with no-knock warrants require a judge to issue those warrants if a judge can be reasonably located. And I respectfully submit that every single time you have a warrant of that nature referred to in lines 827 to 838 issued by a magistrate, you are going to have a suppression motion that is going to be filed every single time contesting the reasonableness, and this language is even in there, contesting the reasonableness of the efforts of law enforcement to locate a judge, which is going to create a wholly new avenue for litigation concerning the exclusionary rule with respect to evidence obtained pursuant to any of those warrants. I also would point to the provisions beginning at line 870 dealing with the use of deadly force. And frankly, this is one of those provisions that I think did get better during this process, a good bit better. And essentially, I think it bakes into this, or attempts to bake into this, qualified immunity, which, I think is an important concept and something that warrants protection. We ask police officers to do an incredibly difficult job. We ask them to leave their home and their family every single day, knowing that they may be placed in a situation where events are rapidly moving, they're tense, there's no way to anticipate what somebody they may encounter is doing, and asking a police officer to make a decision under those circumstances is a tall order. And police officers who face life and death decisions under those circumstances, just by definition, are going to make a mistake at some point. We are asking them to make life and death decisions under circumstances that none of us would ever want to have to make, and under circumstances that just are not ideal. And I would respectfully submit that while many of the components of qualified immunity are baked into this, essentially judging the actions of a police officer by those of a reasonable police officer under similar circumstances, it kind of mucks up what is a well-established doctrine by trying to encapsulate it in this small provision. Take, for example, the use of deadly force provision, in which it says that deadly force may be used where all other options have been exhausted or do not reasonably lend themselves to the circumstances. And this invites the kind of armchair quarterbacking or 20/20 hindsight, the application of that to these split-second decisions in a way that we really can't judge the decision-making of law enforcement officers. So with that, while there is much in this to be commended, I would respectfully submit that these kinds of issues are going to create serious problems for keeping our community safe across the Commonwealth of Virginia. And I would respectfully submit that while I respect the efforts of my colleagues, that this bill maybe could use a little bit more effort in trying to get some of these issues right. So I would hope that the members would look carefully at this and consider casting a no vote on this piece of legislation.
Thank the senator. For what purpose, the senator from Hanover, Senator McDougal, rise?
Thank you, Mr. President. Mr. President, would the senator from Hampton yield for question?
Will Senator yield? Senator Yield, you have the floor.
Thank you, Mr. President. Mr. President, I'd ask the senator, I'm focusing in on two places. One is the newly created code section 15.2, 1721.1, and 2.2, 5515, and it talks about either a law enforcement or a locality accepting items that might have been from the U.S. Department of Defense. And Mr. President, I'd ask the senator, as I read those, it indicates that items that cannot be accepted are tracked vehicles, vessels, and any vehicles of any other kind. Is that accurate?
Senator's the floor.
That is correct, Mr. President.
Mr. President, would the senator yield for additional question?
Senator Yield. Senator Yield, you have the floor.
Mr. President, I'd ask the senator, it does not appear to be any exception for natural disasters, say in the area that I represent, where we have a disproportionate strike of hurricanes and nor'easters, and sometimes the National Guard will come in with military vehicles that might be owned not by them, but by the U.S. Department of Defense to help with some of that destruction. Is there any exception written into the bill for use of those vehicles?
Senator's the floor.
Mr. President, this does not cover the National Guard.
Further question?
Mr. President, I would, yes, further question. Would
Senator Yield? Senator from Hampton, Senator Yield? Senator Yield, you have the floor.
Mr. President, I would ask the senator if the Guard or anybody from the military was in on those relief efforts and a vehicle was used that title was to the Department of Defense, would that not be in violation of this code section? And why not?
Mr. President.
Or locality, or the locality.
Senator from Eastern Fairfax, Senator Servo.
The senator from Hanover yield for a question.
Look, Mr. President, I would yield if the senator is going to answer the question that I proposed.
Is that what the senator wants to do?
Yeah.
Okay. Well, the senator from Eastern Fairfax has the floor.
Thank you. Mr. President, I would ask the senator from Hampton if he would look at line 25 of the bill, which the section he's relying on, and note that ASME sees in the statute where it says that this prohibition only applies to weaponized aircrafts, vehicles, or vehicles of any kind, not vehicles generally, but weaponized vehicles, which is consistent with the federal standard the Obama administration adopted in 2015. Does he see that part of the sentence?
Mr. President.
Senator from Hampton, or Hanover.
Is that,
Senator from Hanover, you have the floor.
Thank you, Mr. President. I would answer the gentleman. I see two places in two different code sections. One just says tracked armored vehicles. It does not make any determination of armament. And the other says weaponized aircraft. Then it says vessels. And then it says vehicles of any kind. And weaponized, I see no definition of in this section. So I understand what the gentleman is trying to articulate. I'm not sure the words that are listed out in this section comes to the same conclusion he's trying to articulate.
Senator from Eastern Fairfax, Senator Servo.
Now I'll speak to the bill at the appropriate time.
Okay. Senator from Hanover.
Thank you, Mr. President. Mr. President, I think that exchange indicates, as the senator from Harrisonburg eloquently previously described, that this bill does have some issues that are not yet described. In the area that I represent, we've certainly seen a lot of challenges with flooding and sea rise, a lot of issues with tornadoes and tropical storms. Just this past week, Windmill Point was devastated in some areas by tornadoes that were spurred from those. Mr. President, a reasonable person could look at this language and said if a locality received help and that help came in the form of a vehicle that somehow the federal government had title ownership to, then they wouldn't be able to receive any more money for their law enforcement. Mr. President, I think I heard from the senator from Eastern Fairfax that that was not the intent that he was trying to go for, but that certainly does not appear to be how the words written into the statute currently read. And Mr. President, when we're moving forward, it is extremely important that we get it right for making sure that law enforcement are certified in the correct way, and that law enforcement that have not done a good job get decertified and can't work in other places in the Commonwealth of Virginia. That is a laudable goal and one we should all strive for, regardless of what side of the aisle you're on. But, Mr. President, this bill does a lot more than that and can have a lot of implications, particularly for small jurisdictions like the ones I represent that don't have a lot of resources, that are not receiving a lot of money from the state or federal government, and find themselves in situations where we need help, and we need that help to come immediately, and that help cannot be at risk of losing all of our funding for other law enforcement when that time of crisis arises. So, Mr. President, I understand some of the laudable goals, but I would also encourage the body to not move this measure forward, to make sure that we're focusing on the right things and not catching other things unintended into that net that could do damage to parts of the Commonwealth.
Mr. President.
Thank the senator. Senator from Williamsburg, Senator Mason.
Will the gentleman from Hanover yield for a question?
Will Senator yield?
I'll yield.
Senator Yields, you have the floor.
Mr. President, I asked the gentleman, not in the section that the gentleman from Eastern Fairfax referenced, but on line 701, the section that he's referencing that does not speak to the weaponization of the vehicle, Could the gentleman read us the title or just line 701?
Senator's the floor.
Mr. President, I could read 701, but mine is in the highlighted version, so I don't know which line that is.
But Mr. President.
Senator's the floor.
Mr. President, that is the section that he was just referencing if the National Guard comes to his area to help. That section 15.2-1721.1 is defined as the acquisition of military property. So, Mr. President, the gentleman yield for one more question.
Senator yield.
Mr. President, I'll yield and I'll answer. Now that I know what the code section is, I can answer the gentleman's question.
Okay. Does that assuage your gentleman's concern, considering we're talking about the acquisition of?
Senator's the floor. Thank you, Mr. President. Mr. President, no, because even though the title says acquisition, and certainly those of us who have had to argue some of these know that the title is not dispositive, the language says acquiring, purchasing, or otherwise accepting on any terms. So that would mean temporary or permanent, and certainly would include any other terms in times of accepting help during a national disaster. Again, I don't know that I think that that is the intent of the gentleman in moving this forward, but I certainly see the language is very restrictive in giving no exceptions, saying any terms.
I thank the gentleman.
Thank you, Senator. One purpose senator from Spotsylvania, Senator Reeves, rise.
Thank you, Mr. President. I wish to speak to the bill briefly, if I may, and clarify a couple things.
Senator's the floor.
Thank you, Mr. President. I think the senator from Hanover brings up a great point. I just want to let people know there's a device out there that we used in law enforcement quite a bit, and it was a armored up tracked vehicle, but it was called a Talon, Mr. President. And that Talon was a bomb disposal tracked vehicle, Mr. President, and it's used not only in the military but for law enforcement to keep our officers safe at a safe distance to possibly dispose of suspicious items that could be filled with bombs. And under this, and based on the testimony of the senator from Hanover, I think it's a broad definition, and it would include us in our ability to be able to get these vehicles, which are not cheap, but having the opportunity to have them would save lives under tracked armored vehicles. And I just wanted to bring that up as one example of some of the technology that's out there and developing all the time. And why would we limit ourselves to have the ability to save people's lives, our first responders' lives, whether that be firemen or those folks who respond to these things, by having armored up vehicles? I understand what the intent is when you look at line 700 under little 5, grenade launchers. Sure, Mr. President, nobody wants riot gas launched at them. Last time I looked, grenade launchers from law enforcement were not used to send high explosive rounds into the citizenry. So I understand the intent of that. They make handheld ones, so that's what they'll have to go back to. But, Mr. President, I understand this bill. I know what they're trying to do. I appreciate the intent. I would associate my comments with the senator from Harrisonburg as well. There are many items in this bill, this omnibus bill, that I would like to vote for. But because we're going to limit and tie the hands of our law enforcement to keep them safe, I just can't do it. Thank you, Mr. President.
Thank the senator. For what purpose, senator from Roanoke County, Senator Suderline, rise.
Thank you, Mr. President. Speaking briefly to the bill.
Senator has the floor.
Thank you, Mr. President. I, like the senator from Rockingham, commend the authors, the senator from Hampton, senator from Eastern Fairfax, for so many of these things. I think the bill's gotten a lot better. But the larger approach is what is really disappointing to me, and I just want to mention right now, I think we do a lot of things better than Washington, and I think one of the reasons is that we actually work together a lot more, and one of the reasons is we have standalone bills, so there's a lot more opportunities for us to work together. And one of the greatest disappointments to me during the regular session was there was landmark legislation brought forward by the senator from Alexandria that included 2 items that I'd advocated for several years, and not everyone in my party always appreciated that I advocated for them, but they're things I thought were important, but because they were wrapped up in such a large omnibus bill that had other items that I couldn't support, I was not able to support that legislation. And so I find myself again today with a bill with many things that I'd like to support, but they've all been wrapped in together and it prevents me from doing so. And I fear that every year that passes in the General Assembly, we get a little closer to further embracing this omnibus approach. And I really don't think it's a good idea during a special session especially, but I hope it's something that we'll get away from and go back to trying to do more standalone bills.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5030? For purpose, the senator from Eastern Fairfax, Senator Sarabel, rise.
Thank you, Mr. President. Speaking to the bill.
Senator, has the floor.
Thank you. So I want to clean up a couple of the items that we've heard raised about this so far. First of all, this issue about the standalone bill. The intent behind that was not to try to jam anyone or, force anybody to have to vote against the bill. The intent was to try and save us some time. We're in a special session, and the other body, I guess, decided to turn this into at least 12 bills, maybe more, I'm not really sure. But if you can imagine trying to debate 12 bills instead of one, we probably need an additional day of session to work through all that. So that's, and not to mention the committee meetings. So, I mean, that's the only reason we went with the omnibus approach versus the standalone bill approach, is we're trying to get us out of here. We did an omnibus this year on the transportation bill. Senior Senator from Fairfax's transportation bill. House Bill 2313 a few years ago was an omnibus. It's not an unusual approach, or we do that from time to time. Second thing, with regard to this military equipment piece, I don't think this language is being read correctly, Mr. President. Every one of these statutes talks about acquisition of property. They also don't, I'm sorry, it talks about acquisition of property, which doesn't mean when somebody comes in to help you. It means when it becomes yours, you gain title to it. And I would also just note that this doesn't prohibit any police department from buying a bomb tractor or whatever that thing is, or hand grenades or anything else. This prohibits them from getting it from the federal government. And because the federal government has a program where they make certain equipment available to folks, and that's what this has to do with. And the list is the exact same list that the Obama administration implemented in 2015 before the Trump administration repealed that policy in 2016, with the one exception, which is that we did not include camouflage uniforms at the request of the Virginia Sheriff's Association. And the Virginia Sheriff's Association looked at this language, and they specifically articulated that they wanted to be able to acquire vehicles for high water rescues, and they don't think that that is prohibited by this language. So, this language has been vetted by those third parties, and they don't have the same concerns that I've heard articulated. I would note that with regard to the discipline issue raised by the senator from Rockingham, the Law Enforcement Procedural Guarantee Act was enacted in 1978, and last time I checked, we didn't have collective bargaining authorized until a few months from now. So, these discipline issues don't have anything to do with unions. The Law Enforcement Procedural Guarantee Act has been on the books now almost my entire lifetime. And those issues are separate and apart from whatever a union might have to do with anything. With regard to the search warrant issue, if there's a concern that somebody's going to have to litigate a search warrant issue, I have two ideas for law enforcement. Number one is make sure you find a judge. If a judge signs it, then the reasonableness of finding a judge ain't going to be a problem. Number two, serve it in the daytime, because that language only applies if you want to serve a warrant at night. And that's the way the FBI serves most of their warrants. And it's, I think, in some ways, less likely to result in conflict if a warrant served in daytime rather than at night. So that was the intent. It's a safer process. And lastly, I just want to say with regard to the use of force stuff and the qualified immunity discussion, just so everybody understands I'm not sure if everybody here understands what qualified immunity is. But basically, the idea of qualified immunity is that a law enforcement officer can be immune from a 1983 action, which is an action violating civil action for violating somebody's constitutional rights. They can be immune if there's ambiguity about what the law is on that. And so if there's a clear rule, if there's a clear standard, you do not get qualified immunity. This bill puts a bunch of clear rules in the code, so you don't have to go and read a bunch of cases to try and figure out what the law is. So in many ways, by putting this in the code, we were taking qualified immunity out of the mix for those use of force situations where somebody would be violating that statute. So I think that's people are kind of getting it backwards on that. And I would also just note with respect to looking at a police officer's conduct from an objective standard, that is from a reasonable police officer standard, That is exactly what the law of the United States of America is right now. 1989 Graham v. Connor, which is the U.S. Supreme Court case, which this statute was based on, the U.S. Supreme Court wrote, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight. And that's what the U.S. Supreme Court wrote. That's the law today. It's been the law since I graduated high school in 1989. And so if you got a problem with that standard, go talk to the U.S. Supreme Court. But we were just trying to get that into the code so it's clear. So, the concerns I've heard articulated, I don't really, Mr. President, I don't really feel like are valid concerns with respect to this bill. I think there's some other issues we could probably talk about that I haven't heard on the floor. But this bill, as passed, is going to make law enforcement in Virginia much safer. It's going to make our police department stronger. The language in here that says they're not going to get a House bill, get HB 599 funding in the future unless they get accredited in the next 4 years is going to go a long way towards professionalizing our police forces that aren't accredited right now, unlike our Capitol Police or some of the larger divisions. And that's why a lot of the law enforcement agencies and associations support this bill, because they think it's going to make policing in this Commonwealth better. And I'm really proud that we're going to take this historical moment that was caused by George Floyd's unfortunate murder to make some lemonade out of those lemons. But I think this is a really important achievement. Hope we vote for it.
Mr. President.
Senator, what purpose senator from King George, Senator Stewart, rise?
Mr. President, would the gentleman from Fairfax yield for a question?
Will Senator yield?
I'll yield.
Senator Yields, you have the floor.
Thank you, Mr. President. I'd ask the gentleman, based upon what he just said, I want to make sure I understand this correctly. So was the gentleman saying that law enforcement would no longer have that level of qualified immunity above what now they could be sued for and risk management insures them for? In other words, would they now have personal liability if they served a search warrant at night and either, if you look at line 830, it was later determined that they didn't announce their purpose and authority loud enough or sufficiently, or another example is that it's later determined that even though a judge or a magistrate indicated there was good cause to serve that at night, under a motion to suppress, it's fleshed out that it really wasn't. So if I understood the gentleman correctly, those officers would now lose that immunity from personal liability if a court, after the fact, determined they had violated either of those two situations.
Senator has the floor.
Mr. President, the way I would answer the question is this, which is that the problem with qualified immunity is that if there's any ambiguity about what the law is, then qualified immunity kicks in. And so I'm not a civil rights expert. I've only done a couple 1983 cases. But if there was a case out there that dealt with that specific fact pattern and what was reasonable and unreasonable, a case on the books, then I think a judge would probably find they don't have qualified immunity. But if there was ambiguity about what the law in that scenario was before the police went into that house, they would have qualified immunity. I think it probably would end up being a judgment call by the judge overseeing that civil case when the time came. But I'm not sure that that part of this statute really changes that issue a whole lot off what it is today. I mean, today, if a law enforcement officer improperly obtains a search warrant and executes it, they could get sued for it today, and the judge would have to figure out whether there's qualified immunity or not. This just creates an additional rule to provide a basis for getting around qualified immunity, but it doesn't guarantee there will be no qualified immunity.
Further question?
Looks like I confused him.
Speaking to that, Mr. President, if I may.
Senator has the floor.
Mr. President, this was a bill that I had tried to amend and tried to help on, really wanted to vote for it, but that just scares the heck out of me, because I think he brought up something that I had not considered. And now, if you announce your purpose and authority to enter, which I think is the right thing to do, but after the fact it's determined by a judge that it wasn't loud enough or it wasn't sufficiently, you've now committed an intentional violation for which you have personal liability. and there's no way officers can operate without qualified immunity. It's just simply no way an officer could serve the community without that immunity. It would be prohibitive for anybody to serve in that capacity. And the same is true if a magistrate determined there was good cause for the warrant to be issued then, but then later it was determined it was not. So frankly, those are things I had not considered. The gentleman from Fairfax bring those up, and I think that's a pretty critical flaw in this bill, and maybe we ought to slow this down and make sure we're getting it right, because it gives me a great deal of pause now, having heard that from him.
Thank the Senator. For what purpose is the senior senator from Fairfax, Senator Safslaw, rise?
They can correct me if I'm wrong, but I thought I heard somebody in here express opposition to this bill because the local police wouldn't be able to get their hands on even a hand grenade. Now, granted, I was in the old Army, and maybe the hand grenades of today are nothing more than firecrackers, but I can tell you the ones that I threw in basic training and in war games over in Germany, if I were to lob that in between where Senator Reeves and Senator Favola sit, I would kill at least 9 people in here. These are not play toys, and I can tell you there isn't a police force in America that needs one of them, or anything even remotely close to it. So this bill is, and I would agree, it's not a perfect bill, but we could work on this thing forever, and it still wouldn't be perfect. And as time goes by, I'm sure there'll be some modifications to it. But we have a pretty serious problem in this country, you know, and it didn't just start with George Floyd. It's been going on for quite a while. I mean, just take a look, just in the last few months, guy falls asleep in his car in the drive-through line in Atlanta, Georgia, and winds up dead. Guy out for a jog. I think it was also in Georgia, I'm not sure. Winds up dead. A guy having a nervous breakdown in upstate New York, essentially with no weapons, winds up dead. They all had one thing in common, and that was the color of their skin. And we got a problem, you know, and that we need to face up to, we need to deal with. Like I said, the bill's not perfect, but, you know, I talked with Wayne Huggins, who was formerly the head of the state police and now their lobbyist, as well as the representative of the sheriffs, and they were pretty satisfied with the condition of this bill. And like I said, it's not perfect. We could work on it for a long, long time and it still wouldn't be. You could probably still pick it apart, but we got a big problem in this country and we need to face up to it. And this is a pretty good start. We're not going to do away with qualified immunity. I'm pretty confident of that. That's a very complicated issue that requires an awful lot of work. But this bill is a good start towards dealing with the problems that we have in this country. And everybody in this room, all 39 of you, know we have a problem. So anyways, I would hope that, you know, you all would throw your support to this bill. It's not a bad bill.
Thank the Senator. For what purpose is Senator from Russell, Senator Chafin, rise?
Mr. President, I rise to speak to the bill.
Senator, it's the floor.
I have also looked closely at the bill, and the bill has gotten better and better, and I do applaud those individuals who have worked on this bill to make it better. However, the region that I represent in the Senate is comprised of some areas that have very rugged terrain, high summits, high peaks approaching 5,000 feet, plunging ravines and valleys and swift-moving water. Flash floods occur from time to time. Mudslides occur from time to time. We have blizzard conditions at times. And those times require the types of vehicles that have been acquired by our local sheriff's offices through the years, and they're Humvee type vehicles. They're currently used by the military, and they're prized by our sheriff's offices because those vehicles have a very high clearance that allow them to cross water, allow them to fight their way through deep snow in rescue operations to rescue people. And I'm familiar with one particular blizzard back in 2010 in the county that I live in, where the two Humvees that our sheriff's office has in Russell County were able to evacuate 110 individuals who would have likely have frozen to death, who had no electricity, no probability of electricity, and the weather, the blizzard-like weather, was so bad that nobody could get to them but our sheriff's deputies. And so with that in mind, the questions that the senator from Hanover brought up about the military vehicles, I associate my comments with the senator from Hanover, and I would ask if the senator from Hampton would rise for a question.
Senator Yield. Yes, Senator Yields, you have the floor.
Mr. President, I would ask the senator from Hampton if we could fix this problem or difference of opinion about interpretation right now, simply by inserting weaponized 2 more times in that particular sentence that deals with the military equipment, where it says weaponized aircraft, and then adding the words weaponized before vessels and adding the word weaponized before the word vehicles of any kind, simply through a simple amendment so that there would not be an argument regarding this issue because we have a lot of these type vehicles out in rural Virginia.
Senator has the floor.
Mr. President, I would be more than willing to address this issue as this bill goes over to the House, but I want to be very clear that we are not talking about military equipment as it deals with weather-related issues. And we know for sure that we're not talking about weather-related issues when it comes to military equipment, when it comes to law enforcement agencies and dealing with communities in this regard as it relates to this legislation. That's not what we're talking about here. And we all in this room know it. But I'm more than willing to address the issue as this bill moves over to the House.
And Senator, further question?
Mr. President, a further question.
Senator Yield. Senator from Hampton, Yield. Senator Yield, you have the floor.
I would ask the senator from Hampton if she is willing to make that amendment at this time. At this time, it's a very simple amendment.
Senator has the floor.
President, that means that we then have to move this bill back to second read in order to make an amendment. So not at this time.
Further question?
Yes, Mr. President. Further and final question.
Senator Yield. Senator Yield, you have the floor.
Mr. President, I would ask the senator from Hampton if she is willing to make that amendment, if she is willing to present that amendment before the House committee, if this bill passes.
Senator has the floor.
I am more than willing to, Mr. President, I'm more than willing to consider an amendment in the House.
Thank the senator.
Mr. President, I thank the gentlelady from Hampton.
Thank the senator. For what purpose is the senior senator from Virginia Beach, Senator D. Staff, rise?
Mr. President, speaking to the bill.
Senator has the floor.
Mr. President, I've heard a couple of things here today that kind of bother me a little bit. One of those is the other body has this in 12 bills. It takes a lot of time to put it through in 12 bills, so we grouped them all together in an omnibus bill to get us out of here. To get us out of here, wow. Mr. President, I believe we should never rush to shorten the time we spend on a bill or rush to the time just to jam through a piece of legislation, especially a critical piece of legislation like this. Senate Bill 5030 is so comprehensive and contains so many elements that it will be detrimental to the execution of law enforcement services, that it should be discussed further and given significantly more consideration before this legislation is rushed through and the unintended dangerous consequences are brought upon the citizens of the Commonwealth. Mr. President, our law enforcement officers have their hands tied multiple times a day, multiple reasons. They come up on a stop, their life's threatened every single day. I'd like to see them all go home at night or after their shift. Mr. President, for us to say that, wow, we just want to jam it all together in one bill, one omnibus bill, so we can leave and get out of here. Well, that's not why I got elected, Mr. President, and frankly, that's not how I feel. Today, Herndon Police Chief Maggie DeBoard, the first Vice President of the Virginia Association of Chiefs of Police, said, "There's legislation to completely end no-knock search warrants, despite the fact they're quite rare. There's also a proposed legislation to only serve search warrants in the daytime, despite the fact that many of these criminal enterprises operate solely at night. So who are you going to serve them to when nobody's there to receive them?" Both these measures, especially combined, will not lead to more use of force. Will only lead to more use of force encounters between law enforcement and the community. It'll get more people killed, Mr. President, and that's not what we want. The SWAT team commander from Fairfax County, who knows the risks of serving these types of warrants, said, in the way we've structured these measures will lead to the loss of more law enforcement lives. Mr. President, that's not what any of us want here. Virginia Beach, we have flooding issues. We have an MRAP, which was provided by the military and given to the police department. We use it regularly to access the flooded sections of Sandbridge, where at least one other member here in the General Assembly on the other side has a house. And Mr. President, I don't want to leave people stranded in Sandbridge or stranded in areas of our community when we have the opportunity to get the equipment, not just get the equipment, but get it for free from the federal government. Mr. President, why would we spend additional taxpayer money to have to purchase new equipment when we can get it from the military for free? Search warrants, another piece of this bill, search warrants require audible notice heard by all individuals in the House. Well, Mr. President, if that House were some of the individuals that serve in this body, I've got to tell you that audible notice heard by every member in that House would be pretty daggone loud, because some of the folks on the other side of the aisle up in Northern Virginia have some pretty large houses. Well, Mr. President, there are some things in this bill I really like. For instance, CIT training. I think that's a fantastic thing, and I think every member of law enforcement should do it. And as members spoke before me, there's a lot of good pieces in this legislation. Mr. President, this legislation is not ready for prime time. There's a lot of problems in this that are going to provide additional costs to our localities and also loss of life of our law enforcement. And Mr. President, I don't know about you, I don't know about anybody else in this body, but I think our law enforcement, they've got a dangerous enough job right now, and they don't get paid enough, in my opinion, to have that job. And Mr. President, I think we really need to put some deep thought into what we're doing here. And in fact, when we say that the other body has 12 bills, it takes a lot of time to go through 12 bills, so we just grouped it all together so we can get out of here. I don't think that's appropriate for this body. We're the body that has the deliberate discussions. We're the body that thinks about how we vote, or at least that's how it was for the last couple hundred years. If we want to change that, maybe we need to change the name of the body. Mr. President, I don't think any of us want that. I don't think any of us want to put our law enforcement in harm's way any more than they are in here already today. So, Mr. President, with that, I'd like to make a motion that we take this bill and we send it on to the Crime Commission so it can be studied the way it really ought to be studied, that truly due diligence can be applied to this bill, because this bill is not ready for prime time, in my opinion. With that, I'd like to make the motion we send this to the Crime Commission, Mr. President.
Correct. Well, Senator, unfortunately, we cannot send it to the Crime Commission. From the Senate, it has to be sent to a Senate committee or some other relevant body here in the Senate.
Mr. President, I'm glad you brought that up. Then maybe we should send this back to courts of justice so they can re-refer it to the Crime Commission where it truly should be. There's nobody in this body, Mr. President, that wants to see our law enforcement put in harm's way any more than they already are today. And I believe that this bill would do that if we don't put the appropriate due diligence in it. And if we pass this the way it is now, Mr. President, I'd just be ashamed to say that we're part of this. Thank you.
Mr. President.
Senator from Fairfax City, Senator Peterson.
Thank you, Mr. President. Speak to the motion.
Senator has the floor.
Mr. President, ladies and gentlemen of the Senate, I've been quiet as a church mouse all day today because I wanted to get out of here early, but it looks like that's not going to happen. I just want to say this piece of legislation, I consider one of the best pieces of legislation I've seen in my time down here. And let me tell you why. It's not necessarily that I came up with the idea. It's not necessarily that any one person did. It was a collaboration of a number of ideas by people that we brought forward in June and had public meetings. And I want to thank Senator Servell and Senator Locke that we brought everyone to the table. Chiefs of police, sheriff's associations, civil rights advocates. We got everybody at the table. And as Senator Locke mentioned, not everybody was happy, but we laid down standards in a way that we had not done literally since the 60s or 70s. And people may not be happy with the final product. I get it. I don't expect anyone to be ever happy with a bill of this magnitude. But understand that this was a laborious, painstaking process, and I regard this as an excellent piece of legislation. As you know, I don't go around throwing compliments a lot in this place because you can compliment yourselves, but this was an excellent piece of legislation. We need to vote it through. Thank you.
Thank the Senator. Do any other senators wish to be heard regarding the pending motion?
Mr. President, I'd like to raise the single object rule.
Let's wait 1 second, Senator. Do any other senators wish to be heard regarding the pending motion to re-refer the bill? The senior senator from Chesapeake, Senator Cosgrove.
Not to re-refer. I'll wait. I'd like to speak to the bill at the appropriate time.
Thank you, Senator. Do any senators wish to be heard regarding the pending motion? Senator from Roanoke City, Senator Edwards.
Mr. President, this bill should not be referred back to the Judiciary Committee. This bill has been vetted as well as any bill I've ever seen. All the constituent groups have been involved in this bill. It has been vetted previously on the floor as well as in the committee, and it's continued to be vetted. And this is a dynamite bill, extremely important, landmark piece of legislation. Do not send it back to committee. Let's get this bill passed by the Senate.
Thank the Senator. Do any other senators wish to be heard regarding the pending motion? Seeing none, the question is, shall Senate Bill 5030 be re-referred to the Senate Committee on the Judiciary? All in favor of the motion will say aye.
Aye.
Those opposed, no. No. The noes have it. The motion fails. Senior Senator from Virginia Beach, Senator Distow.
Mr. President, I'd like to bring up the parliamentary inquiry on the single object rule regarding this bill.
Senator has the floor. Do you want to explain what?
Mr. President, well, the single object rule states that each bill should have one specific objective in it, and this bill hits so many that I believe it goes outside of that.
Thanks, Senator. Senate will be at ease.
Thank you.
Senate will come to order. Senators will please take their seats. With regard to the senior senator from Virginia Beach's parliamentary inquiry regarding Senate Bill 5030 and the single object rule. It is my ruling that the bill does not violate the single object rule, since in the title it refers to relating to policing reform, and all the measures relate to policing reform. So for that reason, it does not violate the single object rule.
Mr. Chairman, Mr. President, I've got a quick question of the President, and that would be, did you consider Witchduck versus Hawkins 105, Virginia 242, which says that if the act embraces two objects, the whole must be declared void? Happy to discuss it further, Mr. President.
Now, I understand what the single object rule is, and what I'm saying is it doesn't violate it. So,
Mr. President, and my request was, did you, while you were researching this, did you look at Witchduck versus Hawkins 105, Virginia 242?
Mr. President, point of order.
Senator from Fairfax City, Senator Peters.
Once the President has made his ruling, is there a cross-examination of why he made that ruling?
There's not.
Thank you.
For what purpose does Senator from Rockingham, Sir Obenchain, rise?
Mr. President, and I hesitate to rise to speak a second time, and I'll keep it brief, but Senator from Eastern Fairfax raised the issue of qualified immunity in response to my comments and those of the Senator from King George. And I did litigate police misconduct cases for about 12 years. I had handled probably 200 cases involving the application of qualified immunity, and I do know what it is, and I know what Graham versus Connor provides. And what it does is this. It has a two-part test, and it says that in order for law enforcement to be protected in carrying out their duties from civil liability, the first part of the test is whether the right allegedly violated was a statutory or constitutional right that is clearly established. And it can be clearly established either through judicial precedent or by the express language of the statute or the constitutional right implicated. And it does involve both statutory and constitutional rights. And then the second component of qualified immunity is whether a reasonable police officer could have believed his actions were consistent with the protection of those statutory or constitutional rights. And my concern, and I believe the concerns articulated by the senator from King George, are this. What this does is, in some respects, it does embody and include qualified immunity language in the statute. It does include language dealing with the reasonable police officer under similar circumstances, and for that I'm grateful. I think that that's an important component that we need to make sure that we include in bills like this. But my concern is that one thing that this bill does is it does alter, or perhaps more accurately, confuses the issue of qualified immunity and how it applies, especially in cases involving the application of deadly force. Remember, I talked about clearly established statutory rights, and one of the things that this statute says is that it is unlawful. It is unlawful for a police officer to use deadly force, number one, unless all other options have been exhausted. And I believe that that is an unfortunate turn of phrase. We certainly want to make sure that law enforcement officers act reasonably under the circumstances. However, because of the rapidly evolving, changing, tense, life-threatening circumstances that may be encountered by law enforcement in the performance of their duties, they may not be able to exhaust all other options that might be available. And I would respectfully submit that this language, I don't know whether it alters the equation for qualified immunity or not, but I have pretty significant concerns that it might. Now, these people, these men and women who protect us, they go out there, and we talked a lot yesterday about the wages that are paid to these men and women who put their lives on the line to protect us. And if we're going to do something that not only potentially subjects them to criminal liability, but also subjects them and their family to financial ruin as a consequence of making a wrong decision when they think that their decision is reasonable, if they don't exhaust all other options other than the use of deadly force, it puts these police officers in an incredibly untenable position. I don't want to pass legislation that really creates the only viable option for a police officer in those circumstances to turn around and run. I don't think any of us want to live in communities where we impose that kind of a choice on a police officer. Either subject yourself to prison and or financial ruin, or just get out, dodge, and don't worry, and everybody else is on their own. So that is the qualified immunity concern. Senator McDougal, I think, made a point, and I think it has been confused through some of the debate, but when you look at these provisions dealing with the acquisition of military property, I understand Senior Senator from Fairfax, I don't disagree with him. I don't know that any of our police departments need to be going out and buying hand grenades. But what this prohibition does is it threatens defunding of police departments if they acquire vessels and vehicles of any kind. And I know that Senator from Eastern Fairfax says that only applies to weaponized vehicles or weaponized vessels, but I don't think it reads that way. I think it applies to if the city of Herndon or the city of Harrisonburg acquires a vehicle for free from the Department of Defense, and that program is in the business of giving free vehicles to local governments and police departments around the country. If they acquire a boat or a car or a Jeep or a Humvee, it may very well be that their funding under Section 599 is in jeopardy and can be completely taken away. Now, this may not be the intention of the senator from Eastern Fairfax or the senator from Hampton, and it may not be the intention of this governor, but we're dealing with legislation that's going to be in effect long after we're gone and long after this governor's gone. And we may very well have a board that is appointed by a governor who takes a different view from the senator from Eastern Fairfax. And if the city of Fairfax or the county of Hanover acquires a Humvee or a rescue boat or a hard-bottom inflatable boat, whether it's weaponized or not, they may very well, because of sentiment against the military for one reason or another, find all of their state funding at significant risk if we pass this piece of legislation. So those are the points that I simply wanted to clarify, and I renew my hope that members will vote no.
Mr. President, would the gentleman from
Junior Senator from Richmond City, Senator Morrissey.
Would the gentleman from Rockingham yield for one or two brief questions?
Will Senator yield?
I will yield.
Senator yields. You have the floor.
I thank the senator. With regard to the first prong of the qualified immunity doctrine, isn't the full flavor of the statement from both federal courts and state courts the following: that if the plaintiff is alleging a constitutional or statutory violation, there first must be a clearly established violation vis-a-vis an earlier case or case ruling? Wasn't that the full statement of the courts?
Senator has the floor.
Mr. President, I would say no. That is one of the ways that the right can be clearly established. There are some rights that simply don't need to be interpreted by courts in order to be clearly established, and if statutory language is held to be sufficiently clear as to establish those rights, then that language alone may determine the applicability or non-applicability of qualified immunity.
Would the gentleman yield for another question, Mr. President?
Senator yield.
I will.
Senator yields. You have the floor.
Could you answer this, which has troubled both me and several federal district court judges, including the United States Supreme Court? How can you arrive at the clearly established stare decisis standard if you never get to that first case to begin with? In other words, if I'm not being articulate enough, how can a reviewing court say there is a clearly established case precedent if you never get to that first case at all?
Senator has the floor.
Mr. President, what I would say is that first case could be the case. And in the circumstances that we were discussing here, you may take a look at the language of this statute, and a court may say that in a case where a police officer didn't try to use manual force as opposed to deadly force, he or she did not exhaust all other options as is required potentially by this statute that we are adopting, and that may well be an issue upon appeal as to whether or not in that particular case that may arise from an alleged violation of this statute may be the case upon which later courts will determine whether that right is clearly established. But you're right, in the first case, the court's going to have to take a look at that statutory language and say, is the statutory language clear enough or not? If it is, then I don't need to have a case that's been decided by the Fourth Circuit Court of Appeals or the United States Supreme Court.
Further question?
Would the senator yield for one final question?
Senator yield.
Of course.
Yield. You have the floor.
Given that qualified immunity is a federal defense to a Section 1983 action, what is the problem with creating a separate state cause of action in Virginia that circumvents any qualified immunity defense as set forth by the federal courts? Or another way of asking that same question is, what is your opposition to a separately created state cause of action?
Senator has the floor.
Even though this, I suppose, doesn't have much to do with this bill, I'll gladly answer that. I want people to actually take jobs in law enforcement in Virginia. We have about a 10% vacancy rate right now. 13% of the authorized positions in the Virginia State Police are vacant, and about another 13% of the entire Virginia State Police force is eligible for retirement within the next year. That could be 26% of the entire Virginia State Police force that we need to fill. if my son or daughter were interested in going into law enforcement and we create a cause of action in the Commonwealth of Virginia against police officers, and we say that you are not entitled to any protection in the event that you make a mistake, under circumstances that may be entirely understandable because of the circumstances, because of how rapidly evolving they are, you're going to face financial ruin. The hell if I would tell my child or my sibling or my spouse to ever consider going in to law enforcement. We are going to make Virginia a much less safe place. We have to provide some ability not to armchair quarterback or apply 20/20 hindsight from the comfort of our law offices or judicial chambers or legislative chambers to actions that may require a decision in a split second that may cost that law enforcement officer his or her life. That's why qualified immunity is important, is because we've got to give them the ability to exercise some judgment and to make a mistake. Otherwise, there's no way that we are going to ever be able to fill these positions or keep our community safe or fill the positions in law enforcement in any of our communities with the kind of people that we're talking about trying to make sure do fill these positions. We're going to be in a bad way if we create that cause of action that circumvents qualified immunity, and it's a delicate balance, and it is a hard balance, and you talk to judges who apply it. It is very difficult to do that.
I thank the Senator. Mr. President, when it's appropriate, if I can speak briefly to SB 5030.
Senator can speak to the bill now.
Thank you. Friends, we have had this dialogue about qualified immunity because the questions and the points that Senator Obenshain raised a few moments ago. But let's be clear, SB 5030 does not establish a qualified or does not end qualified immunity in Virginia. Indeed, that bill may be discussed, a House bill may be coming over to the Senate, and we may be discussing that later. This bill, SB 5030, doesn't deal with the conversation that the Senator and I have just had. While it is true that there are many points in that bill that is covered in this omnibus bill, one of those things that is not covered is qualified immunity. Now, I'll say this. Yesterday, I felt strongly, and I feel equally strongly today, that there should not be a police union. And I discussed that when we were talking about and debating Senator Stanley's amendment. But notwithstanding that, there are so many good portions of this bill that will make Virginia better and safer that I'd ask for its passage. Thank you, Mr. President.
Thank the Senator. For what purpose does the senior senator from Chesterfield, Senator Chase, rise?
Thank you, Mr. President. I rise to speak against Senate Bill 5030.
Senator, has the floor.
Thank you, Mr. President. I stand today with our law enforcement today, and I appreciate all the comments that have been made by my colleagues, many of who are attorneys and have done such a great job today, and I'm not going to repeat any of the same points that they have made. But what I would like to share with you, Mr. President, is that law enforcement today, they are watching us. And they want to know one of two things. Are you with me? Mr. President, that's the only thing they want to know. Yes, this is a very complicated omnibus bill, but it sends one clear message to our law enforcement. Are you with me? Mr. President, the long and short of this, we have law enforcement all across Virginia right now who are listening to the conversation and the dialogue in this body today. And they're going to make a decision. Do I continue in law enforcement, or do I find another occupation? Do I go into another trade? Because the career that I was trained to do is now being critiqued by Monday morning quarterbacks who don't have their back. Mr. President, it's easy for us to sit here and critique what our law enforcement is supposed to do and what they shouldn't do, but the honest to God truth is that not many people in this body have experienced the same pressure and the same stress that they have in the line of duty when seconds count, and they have to make a decision, Mr. President, on what to do, even if it means taking a life. Split seconds, when their adrenaline is running and seconds count, what do you do? And Mr. President, I'd like to believe that our law enforcement has been properly trained to do the job that we have called them to do. And how dare us to sit here and question when we're just Monday morning quarterbacks? We have to give our law enforcement the benefit of the doubt that in situations that are precarious and decisions aren't concise and clear and they're making split-second choices, we are limiting the tools for our law enforcement to use not only protect themselves in the height of a situation, but to protect the public. And as I was traveling in this morning with my bodyguard, who is former law enforcement, he made a comment to me. A couple things. First of all, we already have the Department of Internal Affairs. That's already in place. If we have these grave concerns, which I also share with many of you all, then that is the proper place to go, the Department of Internal Affairs. Listen, many police officers don't get to continue to be law enforcement officers because there's an internal process already in place that takes bad officers off the street. Everyone knows the situation with the Capitol Police that I had to endure this year. I know what it's like to be the victim. And I am thankful to say, Mr. President, that law enforcement officer is no longer with the Capitol Police. I would say, allow the system to work. I fully support our law enforcement, and I will continue to carry the Fraternal Order of Police legislation. And I continue to support getting those officers who do not need to be on the streets off the street. But Mr. President, our law enforcement who are listening to us today, we're sending them a message of whether they're going to continue in law enforcement. And if they leave, Mr. President, we are putting the criminals in charge in Virginia. The very summary of this says that add law enforcement officers to those persons who are guilty of a Class 6 felony they are in a position of authority over. We are making our law enforcement officers felons, Mr. President. I think we need to take the politics out of policing today and allow the Department of Internal Affairs to do their job, Mr. President. And for that reason, I will not be supporting Senate Bill 5030. Thank you.
Thank the senator. For what purpose is the senior senator from Chesapeake, Senator Cosgrove, rise?
To speak briefly to the bill, Mr. President.
Senator's the floor.
Mr. President, ladies and gentlemen of the Senate, just a couple of ideas about this. The bill requires accreditation of police departments throughout the Commonwealth, and I hope that in the budgeting process that funding for that accreditation will be found, at least help for that accreditation, for some of us smaller forces throughout the Commonwealth. I think that's going to be critical to them being able to meet that need that's in this bill. Secondly, I have to say that the gentleman from Rockingham made some really good points about the split-second decisions that our law enforcement officers have to make, and especially them being questioned, did you use all other means? When somebody draws a pistol on you, what is he supposed to do? Do I use my taser? Do I use my club? Should I draw my weapon? What's he supposed to do? I mean, I just don't know what in the world a police officer is going to think they have to do. And also, getting rid of no-knock warrants, we're going to kill a lot of people doing that. Unfortunately, a lot of police officers and civilians will be injured in that. I would ask, and this isn't a question, but I hope that the senator from Hampton, when she's working with the other body, might take a look at the tracked vehicle language that's in here. We're in a hurricane-prone area in my part of the state. There are many times when it takes a tracked vehicle to get over downed trees and limbs and get onto the beaches and try to rescue people. I'm not asking for M1 tanks or, in Senator Saslaw's world, half-track or whatever. But if we can just look at that, they don't have to be armored, of course, or weaponized. But those tracked vehicles can be very, very important to rescue folks in our area of the Commonwealth. And actually, even the senator from Eastern Fairfax could actually use those to help get shopping carts out of a lake, I guess, if he wanted to. There you go. All right. I want to say one final thing about this and our law enforcement. I personally commend our Capitol Police. I think they're one of the finest groups and organizations of any state in the United States. Ladies and gentlemen of the Capitol Police, thank you for what you do for us. Most of us really value you. Thank you, Mr. President.
Thank the senator. For what purpose, Senator from Roanoke City? Senator Edwards, rise.
Mr. President, speaking again in favor of the bill.
Senator's the floor.
I mentioned earlier, this bill has been vetted as much as any bill I've ever seen, and it's landmark legislation. The issue has been raised that because there are standards here, the standards apparently have been assumed they're saying there are rigid standards. They're not rigid standards. They're standards, but the standards are also flexible in nature. And the idea that this abolishes qualified immunity is not true. And as somebody who's a former prosecutor that supports law enforcement, I strongly support this bill. Let me give you an example, Mr. President. It's been said that, well, these standards, if you violate the standards, it abolishes qualified immunity. Law enforcement can be sued. That's not the case. As an example, prohibited practices during an arrest or detention. It says one prohibited practice is neck restraints is prohibited unless the use of a neck restraint is immediately necessary to protect a law enforcement officer or somebody else. You should not have a willful discharge of a firearm into a moving vehicle. But then it goes on to say, unless the discharge of a firearm is necessary to protect a law enforcement officer or another person. Then it goes on, deadly force. During an arrest or detention, it goes on to say, for example, you should not use deadly force against a person unless the law enforcement officer reasonably believes deadly force is immediately necessary. And it goes on to say you need to give a warning if you're going to shoot somebody or use deadly force. Then it goes on to say, if feasible. And you look at the totality of the circumstances. Is it reasonable under the circumstances? A long list of possibilities. I could go on and on and on. In every case, there's a reasonable standard. In every case, there's an unless. In every case, if necessary. And you look at the reasonable officer's belief under the circumstances. It goes on and on and on. I could go down each and every case here. It provides flexibility. If the officer believes that's necessary and there are circumstances that indicate that it is necessary, the officer is not going to be sued because of this, Mr. President. But what this does do, it provides guidance, it provides standards in terms of training, and if somebody does intentionally violate, that's a different matter. And so, Mr. President, I think we need to lay to rest the idea that this abolishes qualified immunity. It does not abolish qualified immunity, Mr. President. It very clearly does not. And I urge that the body vote for this very important landmark legislation. Thank you, Mr. President.
Thank the senator. For what purpose, Senator from James City County? Senator Norman, rise.
Thank you, Mr. President. I rise with some trepidation but resolve to speak to the bill, sir.
Senator has the floor.
2 points that I would like to share with the body. Mr. President, I do believe that my first point of disappointment is that there was an avenue for a bipartisan approach and support on many of the elements of this omnibus bill. I've dealt with one or two of omnibus bills in my career. I'm pretty conversant with the one object rule. It's unfortunate, while I do think it is an exceptional piece of legislation, that there are some warts on it that could have been worked out in this body had there been acceptance of amendments. But that's a process situation. And so I am disappointed that I don't anticipate a lot of bipartisan support, but hopefully as the bill moves its way through the other body that there will be some adjustments to it. The second point is I've listened very attentively to the comments that have been made by all of the senators today. And I think all of the senators but one have spoken from their hearts and their minds on what they believe in the appropriate version of this legislation. I must say I am appalled. I am appalled at the hypocrisy of what I have heard from the senator from Chesterfield. It is unbelievable to me what I've heard her state in light of her behavior and conduct. And it is particularly egregious, Mr. President, that the inference on that officer, where she dropped the F-bomb on, that officer left the Capitol Police because of what she did. It is an absolute, unequivocal misrepresentation. That officer left to take a federal job that was enhancing her career and compensating her more, and I take exception to it.
For what purpose is the senior senator from Chesterfield, Senator Chase, rise?
Thank you, Mr. President. I would like to respond to those remarks that were just previously made. I would say, Mr. President, that I'm 100% in favor of due process for all people, including legislators here in the General Assembly, and no due process was given to this legislator. Thank you, Mr. President.
Do any other senators wish to be heard regarding Senate Bill 5030? Seeing none, question is, Senator from Hampton, Senator Locke.
Thank you, Mr. President. I just want to once again move that Senate Bill 5030 pass, and a few final remarks, and to say that this bill is not anti-law enforcement, and even though it's been misrepresented as that and demagogued as that. Also that there are a lot of good pieces to this legislation, as has been stated by several individuals, and that several individuals have indicated that there are many good pieces to this legislation that they would like to support, although only one individual introduced a bill that has one of these pieces in it. So if individuals truly liked pieces of this legislation, they would have introduced legislation that had these pieces in it. I would also like to state, Mr. President, that 2 and 3 years ago, I introduced pieces of this legislation in this General Assembly. I introduced officer-involved shootings. I introduced disclosure of information regarding law enforcement officers. I introduced discertification in professional standards of conduct as it related to law enforcement officers. What happened to those pieces of legislation, Mr. President? They did not get out of courts. So if people were truly interested, then they would have had a fair hearing. You know, those pieces are in this legislation. So I've also heard that deep thought needs to go into this legislation. Well, I will say to you, Mr. President, deep thought has gone into this legislation. And that people are concerned about loss of life. Mr. President, I'm concerned about loss of life of people who look like me. You know, that's why this legislation is coming forth here in this special session. I've heard that we need to slow things down, you know, put the brakes on. Mr. President, we've been slowing things down for 401 years. You know, so I think that, you know, we've slowed things down long enough. You know, and it's time that we begin to effectuate some fairness here and some justice here. So with that, Mr. President, I move that Senate Bill 5030 pass.
Thank the senator. The question is, shall Senate Bill 5030 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. Senate Bill 5030 passes. Senior Senator from Fairfax, Senator Saslaw.
I didn't think I was going to get a chance to ask this question. Mr. President, I would ask the clerk, this is complete the calendar.
Yes, sir.
Thank God.
Thank you, Madam Clerk. Is there any other business to come before the Senate?
Sorry.
The senior senator from Fairfax, Senator Saslaw.
Just very briefly, the schedule. We are going to go into recess until Monday. That will be a pro forma session. We will come back here, the whole body. Tuesday, we will meet at 4 o'clock. So you get stuff done in the morning, okay? Then we will meet again here at 10 o'clock the next morning, which will give us a chance to finish and get out. That should clear, with the exception of the budget, all the Senate bills. And Courts Committee, which is going to meet with, as Senator Edwards announced, within a few minutes after we adjourn, they will meet again on Wednesday morning, immediately following the adjournment of Wednesday's session.
Thank you, Senator. For what purpose is the senior senator from Virginia Beach, Senator D. Staff, rise? You okay? For what purpose is the senator from Roanoke City, Senator Edwards, rise?
I just want to reiterate, Mr. President, that the Judiciary Committee will meet no later than 15 minutes after we recess today for one bill.
Immediately.
Immediately? I said no later than 15 minutes. We'll meet as soon as we can for one bill, and then we'll meet on Wednesday morning after the session that starts at 10 o'clock a.m. And right after that, the Judiciary Committee will meet again to handle as many bills as we possibly can that have come over from the House. Any questions about that? Thank you, Mr. President.
Thank the Senator. For what purpose is the senior senator from Virginia Beach, Senator D. Staff, rise?
Mr. President, I rise for a point of personal privilege.
Senators, the floor.
Mr. President, tomorrow, September 11th, marks the 19th anniversary of the horrific terrorist attack on our nation. The attack that killed 2,996 people. Among these lives lost were 343 firefighters, paramedics, 23 New York City and 37 Port Authority police officers, 403 brave men and women that died not from the attack itself, but because they selflessly rushed to the scene and worked feverishly to help others. We also cannot forget the heroes aboard Flight 93, like Todd Beamer, that courageously fought to prevent yet another strike on a symbol of America at the cost of their own lives. We mustn't forget that there were thousands of others not immediately killed on September 11th, but instead from their valiant efforts following the attack. More than 10,000 first responders have been diagnosed with cancer attributed to the exposure of the myriad of toxic chemicals released at the scene. It's estimated that the lives lost from this exposure will exceed the number of lives lost in the attack itself. Lastly, we must also remember the dedicated men and women that answered the call to fight terrorism and served in our armed forces. More than 6,000 Americans lost their lives and have been lost, and over 50,000 others were wounded in our nation's military response to the September 11th attacks and ongoing efforts to defend our country from terrorism. Mr. President, I ask that when the Senate adjourns today, we do so in remembrance of the attack and pray that we can return to the unity that our nation experienced on September 12th, 19 years ago. Thank you.
Thank you, Senator. Do any other senators wish to be recognized? Seeing none, the clerk will report any announcements on the desk.
Today, what is today? Thursday, sorry. Today, Thursday, September 10th, 2020, the Committee on the Judiciary will meet immediately upon adjournment. Immediately upon adjournment. Please don't forget to take the hand sanitizer at your desk home with you. If you can't use it, give it to friends and neighbors. We have even more, so take any personal items home with you. We have to break down this facility tonight and then put it back in place on Monday. Monday, there will be a pro forma session at 3:30. The Committee on Finance and Appropriations will have their regular meeting, monthly meeting Tuesday, September 15th at 9:30 a.m. This will be a virtual meeting. Full session will be Tuesday, September the 15th at 4 p.m. Schedule has changed so much, I'm totally lost. The Committee on the Judiciary will meet Wednesday, September 15th, 15 minutes after adjournment of full session. Full session will be Wednesday, September the 16th at 10 a.m.
Thank you, Madam Clerk.
Mr. President, I move that we stand in
Senior
recess.
Senator from Fairfax, Senator Saslaw.
Yeah, I move that we stand in recess until 3:30 p.m. On Monday, which would be a pro forma session.
Question is, shall the Senate stand in recess until Monday at 3:30 p.m.? And then when we do so in the honor and memory of victims of the September 11th terrorist attacks. All in favor of the motion will say aye. Aye. Those opposed, no. The ayes have it. The Senate stands in recess until 3:30 p.m. on Monday in honor and memory of the victims of the September 11th terrorist attack.